it has been said a number of times that a grand jury nowadays, a prosecutor could walk them into indicting a ham sandwich. A grand jury's job was supposed to be the check that would stop government officials from abusing their investigative and enforcement powers. It certainly flies in the face of all of that history of trusting ordinary people to make hard decisions, right? It's almost as though
it's anti-democratic in many ways. So, Matthew, if I'm hearing correctly, the state has expanded its powers, particularly over the last century. And even though prohibition has gone, the prohibitory nature of the state and the penal nature of the state has remained.
Folks will remember the killing of Alex Preddy, who was a protester in Minneapolis, by immigration agents. One of the most shocking things about that was folks ranging from Kash Patel, the head of the FBI, to senior Department of Justice officials said, you don't have a right to carry a gun to a protest. You don't have a right to go armed where police officers might be. What a shocking change politically from where we were 10 years ago.
Welcome to FO Talks. With me is Matthew Cavedon of the Cato Institute. He is a fantastic scholar, a jolly good chap. And today we are going to talk about why jury empowerment matters. Matthew Cavedon, have I got the title right, or would you like to rephrase it as jury education?
I think jury empowerment is the perfect word. What we're here to do is to tell people about the power that juries are supposed to have under the Constitution, the power that people actually have when they get a jury notice and then go to court. I know a lot of folks see it as an inconvenience, but it's actually one of the great opportunities that we're afforded as citizens under the Constitution.
Excellent. All right, Matthew, welcome, and great honor to have you. Matthew, tell us about juries. How did juries come to be? How did the law develop in such a way? And what is so distinctive about the American jury system? I know I'm asking a lot, but paint a picture for us, sir.
Let me paint a big picture for you, Atul, and thank you very much for that question. The jury system goes all the way back to ancient times. In ancient Athens, as part of direct democracy, the law was seen as belonging to the people, not just in terms of who wrote the laws, but in terms of who judged what was appropriate community behavior. So whenever there was going to be a trial, the free men of the entire city would gather together, would deliberate, would discuss. It wasn't seen as something reserved for just a few professionals or experts, but rather it was seen as the work of the community. And they would sit down and assess whether or not somebody had acted justly or whether they needed to be punished, and then what the appropriate punishment would be. That system carried over in certain ways into Rome and other early societies, where there was this sense of collective justice. Now, our earliest sense of things in the English tradition, which of course is the one that the American tradition descends from, is in the Middle Ages, when tribal councils would gather together. This is in the woods before the Norman conquest. Councils of tribal elders and tribal members would sit down and hash out issues of justice and decide whether or not somebody owed somebody restitution, whether or not they should be exiled or executed, things like that. By the time of the Middle Ages, after the Norman conquest, we have this increased focus on the rights of the people. There are these debates between royals versus commoners and the classes in society, the nobles and the free folk. Of course, those come to a head with Magna Carta, which many consider to be the charter of our liberty, the first written document that spells out how things should be. Magna Carta says that no free person shall be imprisoned or have their property seized or otherwise stripped of their legal rights, except by a jury of their peers or by the law of the land. Now, here's a part where historians and popular memory might diverge some. Historians place a lot of emphasis on the second half of that clause, which is that people could be punished by the law of the land, even without the judgment of a jury of their peers. If you went back to the Middle Ages and the early Middle Ages, there was not, in fact, a recognized right of trial by jury. However, this principle that nobody could be punished without the judgment of their peers ended up taking on a life of its own. And by the time of the English Revolution and the Bill of Rights in the 1600s, English people believed that in order to lose your liberty or your property or your life, there had to be judgment by members of the community, that this wasn't something that could simply be done by royal agents or by the king. We weren't going to have a system like existed, say, in France, where King Louis would sit underneath a majestic oak tree after Mass on Sundays and just dole out justice. Rather, the English believed that justice had to belong to the people. By the time that William Blackstone is writing his tremendous compendium of English legal history and principles in the late 1700s, he says that a verdict by 12 free peers, adult men within the community, is the prerequisite for any criminal conviction, that there cannot be a criminal conviction without that prerequisite. We see that principle carrying over to the colonies as well. Of course, there's no noble landed gentry in America at that point. And so there is this strong emphasis on participatory democracy. Again, not just in making laws, not just in electing who will lead the community, but in terms of applying those laws to the people who are governed by them. Issues start to erupt before the American Revolution. The English look for workarounds to get out of having colonial juries try colonists who are accused of offenses, especially those that are against the government and those that involve the prerogatives of the crown. So we see a shift toward pushing cases, if they have anything to do with smuggling or taxation or ships, into admiralty courts, which do not follow the common law and are decided by a judge. We also see at one point the most radical effort. King George III actually asks Parliament to revive a law of King Henry VIII from the 1400s, saying that certain crimes...
1500s. Henry VIII was in the 1500s.
For shame, I should absolutely have known that. You're right. An early modern law of King Henry VIII saying that royal commissioners will designate where certain offenses committed overseas can be tried. At this point, the colonists are in a panic. Massachusetts and Virginia delegates condemn this by saying that Britain is making a move to ship Americans to London for trial before London juries. This is still trial by jury, but it's not a jury of somebody's local peers. It's certainly not any kind of local justice. None of these trials, based on the historical record, actually end up happening, but this is a real spark in the tinder pile toward the American Revolution. There's a absolute panic here that the British government is trying to insulate its officers and its opponents from local scrutiny. So after the American Revolution, enshrined in the Constitution not once but twice, is a right to a jury trial in all criminal cases. Article 3, which sets up the judicial system, says that there shall be no criminal trials except by a jury. And then the Sixth Amendment guarantees Americans' right to a trial by jury if accused of a crime. So there's your broad historical sweep. This is a right that was long fought for and hard won over the course of centuries and across two oceans. But that's now an essential part of our legal system.
The question I have for you is, yes, it is the right to be tried by the people, by your peers, instead of an authority above. And because the American Revolution, by its very name, was a revolution, this right is enshrined in the Constitution. Now, my question to you is, this system differs greatly, even today, despite all the revolutions, from the continental one, I mean the European continent. So walk us through the difference between the jury system that we have in the common law Anglo-Saxon tradition and the European tradition, which, as some would say, is more of an inquisitorial tradition.
That's right. I know you have listeners from all over the world. We have two different legal systems that are very prevalent nowadays. One is the common law system, descended from England, and at least in its core fundamentals, that jury right is really, really an important part of that. The idea that ordinary members of the community are selected, and their job is to determine guilt or innocence. Specifically, their job is to assess the facts, and that's true in modern systems as well. Was the light red when somebody drove through it? Did somebody provoke another person to violence? Those are the kinds of questions that in the common law system, judges do not get to decide. Now, you talked about comparing the common law system to the civil law system. I want to do another comparison real quick, which is that historically, juries were invited to look beyond just those sort of narrow factual questions. They were invited to look at the law and at what justice demanded, and to make their own reasonable sense of what is it that the law is actually aiming at, and is this person the kind of person who should fall under its penalty? One of the great...
So very quickly, they
Yes.
were not just looking at issues of fact, but also issues of law.
They absolutely were, and a couple of really landmark cases stood along the way to that as well. One was a Quaker in the 1600s named William Penn. Americans will know him because he went on to found the colony of Pennsylvania. William Penn and several other Quakers were tried for sedition and religious crimes in England. They were tried by a jury, which was appropriate, but the judge intervened and said, the facts here are so obvious that if any juror votes to acquit, they're actually violating their oath to uphold justice and truth and the law. And so he punished the jurors who voted to acquit William Penn and his co-defendants with criminal contempt for violating their oaths and perjury for doing that.
He sounds like an Indian judge. The Indian Supreme Court has the power of contempt of court, which it abuses, even to censor grade 8 textbooks. So he sounds very much as if, in his previous or next life, he was certainly an Indian judge.
Now, that's your area of expertise, and I'll leave that to you, but certainly this was a major concern in that, look, if the judge can come in and say, the government wins because I say so, and if you don't agree with me, I'm going to punish you, then indeed, the decision has been taken out of the hands of the jury. And to their great credit, the English courts agreed when they reviewed this on appeal. They actually, there was intervention from above, and the courts said, this is inappropriate. This is a violation of the right to a jury trial. What that meant is the jury's verdict is unimpeachable. Even if the facts are crystal clear and obvious, the jury is the one who decides, is this guilt or is this not guilt? They are the ones who will make that call. A jury cannot be punished based on finding facts differently than whatever a judge thinks is obvious. Now, to fast forward about 100 years, there was a case a little bit before the American Revolution in England featuring a publisher named John Peter Zenger. He was under suspicion because there were pamphlets going around criticizing the colonial government. His case was put before a jury for seditious libel, which I believe is actually still an offense, possibly in India. It's not in the United States anymore.
Absolutely. Now, all former colonies have retained a lot of colonial laws, whether it is Nigeria or whether it is India, whether it is Kenya or it is Malaysia. So the Eastminster model, something I just pointed out before our interview, very much operates in the former non-Anglo-Saxon colonies. And this is not an original idea. This is Harshan Kumarasingham's idea, who's an academic in Scotland, and he's worked on this. And he said that in all of these countries, you don't really have the common law system as you have in England, because the viceroy, the representative of the Queen or the King, had too much arbitrary power. Over to you, sir.
Absolutely. John Peter Zenger's trial was not across the seas in England. John Peter Zenger was a New York publisher. He was suspected of spreading sedition against British colonial authorities. He was put on trial. And even though there was no defense to seditious libel for truth, so people could be held liable for speaking bad about the government, even if their allegations were true, which is absolutely not the case under modern American law. There was no truth defense to seditious libel. Nevertheless, the jury went ahead and decided that because John Peter Zenger's statements, they found, were true, they were going to acquit him. What that represented was the jury taking not just the facts of the case, but the law into their own hands and making a learned decision based on what they believed that justice demanded. The memory of the Zenger acquittal was very fresh in the minds of the founding generation. It was an important precedent for the American understanding of what juries are supposed to do. Now, to tie this back up by coming back to your original question, which was about the civil law system. In civil law systems descended from the French or the German or the Roman models,
I mean, they all go back to the Roman model, and then you can argue they all go back to the Napoleonic Code. That is the basis of civil law on the continent.
and it's spread beyond that, right? You have aspects of Dutch Roman law that are practiced in South Africa. Japan adopted the German model, as did China. So this has had a global reach. Ordinary people aren't entrusted with decisions like that. In fact, ordinary people aren't even given the are not even given the judgment over facts and over common sense determinations like what would a reasonable person do. Rather, it's seen that judges should be the ones who are responsible for deciding all of those issues with the assistance of learned lawyers and attorneys. Now, I'm an attorney. I've got a professional reason to believe that indeed maybe the world would be better in some cases if it was just us eggheads sitting around and hashing these things out. In fact, when I was working as a public defender in a past life, I had some trials that we chose to have in front of a judge. We had bench trials. And that's the defendant's option as well, is to opt out of a jury. There are some cases that depend on legal nuances that might go over the heads of an outraged member of the community. Nevertheless, that right of being tried by a jury and having them be able to go into that back room and hash things out and sometimes get it wrong, but a lot of the times serve as that important check on what the government is doing and on what the law means in concrete terms for people's lives. That is an essential part of our heritage as Americans, and I would say of other descendants of common law British systems as well.
All right, so you've painted a very good picture. Now, if I understand it correctly, these days, juries do not deliberate on the law. Juries get to deliberate over fact. And of course, the most famous movie, My Cousin Vinny, has immortalized jury trials. But here's a question for you. Do you think this is a good step overall because things have become more complex and nuanced over time, and the law is far more evolved? There's too much precedent, and therefore you need a certain degree of egghead learning to deliberate over the law? Or do you think, are we seeing the whittling away bit by bit of civil liberties and by extension of juries?
Laws have become complicated, right? I don't know that that's necessarily less true than it was hundreds of years ago. In fact, folks who spend a lot of time hanging out around English common law know that it can be extremely technical with tremendous procedural pitfalls. Something like seditious libel and whether or not truth was taken into account, the issue that the Zenger jury in New York dealt with in the 1700s, that wasn't exactly elementary school stuff. And to speak about schooling, ordinary members of the community didn't have public schooling or standardized schooling up through 12th grade like we do nowadays, and oftentimes college beyond that. So I don't think that the task is necessarily that suddenly stratospherically out of reach of ordinary people. Rather, there's been a push, especially over the last 100 years, to try to make the system more utilitarian, to have it be a streamlined, I would even say assembly line to produce convictions. The criminal law system took on new life in the United States in particular about 100 years ago with the rise of prohibition of alcohol and other expansions of criminal law as a tool for dealing with perceived social problems. There was a sense...
So let me stop you very quickly. When does prohibition begin in the US and when does it end? The years?
It's adopted at the federal level in the 1910s and 1920s through a constitutional amendment. It lasts fewer than 20 years, and it's out in the 1930s. There are some state precedents for it, but prohibition ends up creating an entire bureaucracy, an entire apparatus of enforcement and investigation agencies, and of ways of doing justice that never really go away after that, even though certainly folks can go out to the bar and grab a beer. Prohibition is repealed only insofar as it applies to alcohol, not in terms of all of the structures and expectations that it sets up for how criminal law is going to operate. It then takes on an entire new life with the war on drugs and narcotics, starting 1950s, 60s, and then really escalating in the 1970s. And that's the status quo where we live today.
So what we now have is an entire criminal justice complex, as some people would say it, wherein the prosecutors try to secure convictions because that is what enables them to climb up higher, even to political office, Rudy Giuliani being the classic example. And you have a huge prison complex, which then houses people who are convicted and serve their sentences. Would that be fair, or am I being a bit hyperbolic here?
I think you're actually maybe understating it, which is that somewhere around 2/3 of federal judges, and certainly many state judges, their prior professional experience was as prosecutors or as government attorneys. And you have a system now where 2/3 of federal judges, and many state and local judges as well, their only prior professional experience was as working as prosecutors or as government attorneys in other capacities. So it's not just that you have police systems and prosecutors who are going after folks. And by the way, you have federal funding and state funding for law enforcement that's tied to things like rates of arrests, rates of convictions. So you have financial incentives to do that. You also have minimized the role of ordinary people in assessing cases. It has been said a number of times that a grand jury nowadays, a prosecutor could walk them into indicting a ham sandwich. A grand jury's job was supposed to be the check that would stop government officials from abusing their investigative and enforcement powers. We've seen grand juries actually take on a new life in the last 6 months or so, especially in Washington, D.C. and in Virginia, pushing back against some federal prosecutions. But in a lot of ways, the grand jury's role was reduced down from asking questions and investigating to just rubber stamping and making sure technicalities were observed. Then if somebody does end up getting to a jury trial and defeats the pressure to plead guilty, they go in front of a jury that is told over and over and over again, your job is to run a checklist, to check off the facts of whether this fact happened and this one did and that one did, and then to not worry about substantive justice, not to worry about the law, not to worry about the consequences, because all of those are decisions for the judge, and your job is over once you have decided whether it's factual guilt or not. Do not rely too much on moral reasoning. Do not ask those kinds of hard questions about abuse. So all of these have combined to a system now where about 97% of federal convictions come from guilty pleas because there's no real purpose in going to trial. And at the state level, it's around 94 to 95%. Add in the fact that because we have such a complex and overwritten criminal code, prosecutors can decide the price. If you plead guilty, we'll give you a tap on the wrist and some probation. If you go to trial, you're looking at 10 to 15 years in prison and 5 felony convictions. No wonder we have a system where very few people choose to go to trial and to place their fate in the hands of ordinary citizens.
So, Matthew, if I'm hearing correctly, the state has expanded its powers, particularly over the last century. And even though prohibition has gone, the prohibitory nature of the state and the penal nature of the state has remained. And now, if you get caught up in the criminal justice system, the odds are very much stacked against you, unless maybe you're super rich. And the jury system is not much of a safeguard anymore. Am I getting it right?
You are getting it right. The state's functions using criminal law have expanded dramatically. Something like drinking or using narcotics, that's the kind of private activity that unless somebody went out in public intoxicated or was using in public or got behind the wheel of a car or endangered other people, it wouldn't have been the government's concern. Nowadays, we have an entire government apparatus, especially at the federal level, that tackles all those kinds of behaviors. There's also been, less so in recent years, although that's made a comeback as well, a war on guns. Folks may remember in the 1990s, militarized federal government actions to seize firearms in places like Waco, Texas, At Ruby Ridge, Idaho, other things, gun offenses were used as the excuse to send out armored personnel carriers and tanks with battering rams in front of them and militarized police units to seize firearms. Now, it's interesting on that note, the current Trump administration has, in some ways, been a very, very strong advocate for firearms, has protected the Second Amendment in court, argued for a very broad interpretation of it. On the other hand, when it's politically expedient, they're perfectly happy to throw gun rights under the bus. Folks may remember in the first Trump administration, shortly after a mass shooting, the president making a public statement and saying, we're going to come for the guns first and go through due process second. And then much more recently, folks will remember the killing of Alex Preddy, who was a protester in Minneapolis by immigration agents. One of the most shocking things about that was folks ranging from Kash Patel, the head of the FBI, to senior Department of Justice officials said, you don't have a right to carry a gun to a protest. You don't have a right to go armed where police officers might be. What a shocking change politically from where we were 10 years ago, when people will remember the Tea Party protesters, many of whom ended up going on to vote for Trump, showing up and being armed while protesting. So that's just two examples. We also have a government that aggressively uses criminal law in the context of gambling and prostitution, as well as business crimes. We've actually gotten rid of, in a number of ways, intent requirements for business crimes. It used to be bread and butter common law that in order to be guilty of a crime, somebody had to do a guilty act with a guilty mindset. Lawyers will know
even I studied law. I practiced in London. And actus reus in mens rea. You had to prove both the action and the intention. And otherwise, that used to be a fundamental feature of criminal law. Otherwise, you were not really guilty.
And indeed, isn't that one of the big forays, the entry points for jurors to think about criminal cases? Is even if somebody did something, you still have to make the hard call of, does it seem as though, are you satisfied beyond a reasonable doubt that they had a guilty mindset, that they were doing something that was morally wrong?
The classic example is an old lady in her balcony is watering her flower pot and turns and knocks it over with her elbow, and it falls on the priest's head below. And is she guilty of murder? And of course she did the act. She knocked off the flower pot, and the priest died. But is the poor old lady guilty of murder?
Exactly. And those are the kinds of very hard questions that jurors were supposed to be entrusted with figuring out. But now there's this effort to even blind jurors to a lot of the context that decisions are made in. There was a case early on in the early 2000s after California legalized medical marijuana. This was a state-level debate. It ended up going to referendum, and California voters decided to legalize the growing and possession and use of marijuana for medicinal purposes. There was a man who was growing marijuana for the city of Oakland's authorized cannabis program, who was put on federal trial before a jury, and the jury was not told that he was doing this pursuant to a government program. So of course they convicted, because they were told that their only job was to determine whether or not he grew marijuana. That was it. They were not to concern themselves with any background information, and indeed, they were excluded from knowing, as a matter of evidence, about the context for this. Several of the jurors afterwards who voted to convict were outraged and went on public record saying they never would have convicted somebody. This was a community that had voted to legalize marijuana, and they were not told that this was part of their own medical marijuana program. That's just one example of the sort of...
So let me stop you. Where was this case tried? Because this person was growing it in California and then was federally charged. And surely, when he was brought to court, it must have been California or some... So that community in California was unaware of this issue, this context.
That community in California wasn't told that he was growing marijuana for the city of Oakland's own cannabis program. You're right. It was local to Oakland. It was right there in the Bay Area. Of course, had they known this, they would have acquitted him. There's no way that they would have unanimously convicted this man for growing as part of a city-run program, but that information wasn't conveyed to them. And that sort
Wouldn't that be an overreach of the state, and wouldn't that count as a curtailment of personal liberty?
It certainly flies in the face of all of that history of trusting ordinary people to make hard decisions, right? It's almost as though
it's anti-democratic in many ways.
It's as though William Penn's jury hadn't been told that he was upset because he was a Quaker. It's as though John Peter Zenger's jury had been left in the dark about the nature of why he was angry about the government, something like that. That is not the full picture, whole body review that criminal defendants are entitled to. And to come back to your point about civil liberty, if people do not have confidence that ultimately it will be their neighbors and their peers who will make judgments about whether or not they go to prison, sometimes for decades at a time, then I think we have lost a significant amount of personal liberty. We've lost it to legal experts. We've lost it to federal officials. We've lost it to bureaucrats and to judges and to attorneys like me, who are now the ones who are in the driver's seat as far as what criminal justice looks like in our society and what the consequences are.
What in Britain you'd call the blob.
The blob, the machine, the swamp, we might call it in America, right? So this is all deeply, deeply concerning. And even though that was an extreme case that I was talking about in Oakland with cannabis growing, juries in almost all of the United States are left in the dark about the consequences for the defendant if a conviction happens or if multiple convictions happen. Let me tell another story. We've been talking recently at Cato with a man named Paul St. Louis. Paul served on a jury in Fairfax, Virginia, and in his case, the defendant had committed some gun and drug charges. He said that we were told repeatedly throughout the course of the trial that our only job was to determine whether or not this defendant had guns and drugs illegally. He said we were uncomfortable about what it could mean for this man's life, but we also didn't think that there was any reasonable doubt that he had done that, so we voted to convict. Paul found out after the fact that the defendant, Frederick Turner, was sentenced to 40 years in prison on mandatory minimum sentencing that bound the judge. The judge even said that the sentence was excessive, but he said there's nothing I can do about it. That is the way that the law is written. I have to pass this sentence. Frederick ended up committing suicide in prison, and Paul was devastated and has now written for the Washington Post and made other public statements about the things that he wished he knew as a juror, about how he wished that he had understood that he had a choice and that he and his fellow jurors had been able to do something to stop that machine in its tracks. We think it's unjust that jurors are kept in the dark, certainly about their traditional authority to consider the law and the facts and what justice demands, and also about what the consequences are in terms of people's, yes, liberty, sometimes even their lives that flow from a conviction. People may not know that once somebody has a felony conviction, that can affect their ability to apply for a job in about a quarter of professions nationwide. So that can be a major economic burden. It may have impacts on everything from their immigration status to their family. Even a short time in jail or in prison can have a huge effect on people's lives. It can cost them their job. It can cost them their reputation. There was a former federal elected official some years ago who was convicted of corruption charges. He was ultimately acquitted on appeal, but he said, I don't know what court to go to get my reputation back. And we wish that these are the kinds of things that jurors are aware, are empowered to consider when they head in for jury duty.
All right, you've made a very good case as to why jury empowerment matters, and it seems that juries have declined at least over a century. My final question to you, Matthew, is can we turn the clock back?
We believe that we can move toward a system that is more democratically accountable, that belongs to the community again, and that protects liberty by entrusting it to the hands of ordinary people. And in fact, my project at the Cato Institute in the next few months is going to be rolling out a campaign called Your Verdict Counts. That is going to be a public education campaign that is going to have a website and a documentary film and other things that are meant to tell some of these stories and to give people resources to educate and empower people so that when you get a jury notice slip in the mail, you don't just think that this is some inconvenience that's going to take away your time from your work or from your kids, but rather that this is an invitation to do a really important work of citizenship and to push back against that misconception that people are going to be given, that their sole job is to run a checklist and rubber stamp whatever happens, but rather that they are supposed to bring their conscience and their values and their sense of justice and to talk about that with their fellow citizens. So we're going to try to do our part to bring this message out to ordinary people again and to give them the tools that they need to ask hard questions and to make the right decisions in individual cases.
Matthew Cavedon, thank you for your time. Great pleasure talking to you. We'll do this again, hopefully with less background noise next time. Those of you who've been listening to us, make sure you follow our YouTube channel. Make sure you press the bell icon so that you can see newer conversations. We have interesting conversations with insightful people, or insightful conversations with interesting people. Ladies and gentlemen, thank you very much for your time.
Join the conversation at Fair Observer and subscribe to our YouTube channel.